Katie Doyle. That makes it's official. We have some minutes to approve from last meeting. Okay. Well, thank you. I got all in there. Yeah. Okay. Has everyone had a chance to put these? Yes. That being said, I'll accept the motion to accept the minutes. Second. Thank you, David. All those in favor, please say aye. Aye. Minutes are. We, the panel here, we did this, panel zoning board of appeals, meeting tonight. To address, appeal by Shane Brady. Shane had submitted an application, put up a 199 foot flagpole on his property on the Allen Road in town. Is that correct? The code enforcement officer reviewed the application and denied. As a result, Shane has filed an appeal, and that's why it would be. Does the Board of Appeals have jurisdiction to hear this appeal? Shane is a panel resident. The flagpole would be within the boundaries of the town panel on the Elm Road. So yes, we do have the jurisdiction to do this. So we'll start right off. The appellant may state his case. Shane, would you like to?
Yep.
Tell us what.
Name Shane Brady. So I'd like to put. Have you guys ever been to Wyndham Camping World?
Yes.
You know the flagpole that they have out front?
I don't remember specific.
Okay. Basically, I'd like to replace the flagpole that we already have in the field and put a bigger one up that'll match the tree lines. And on my understanding of the ordinance, it's considered an accessory to a principal house structure. And the code enforcement mentioned that it has to go to site plan review. And in the site plan review ordinance, it says accessory uses to primary structures or something along that lines. So I think it should be just a simple building permit instead of a site plan review.
Okay. Parties to the action now state their case. Tim, do you want to?
So first off, Tim Giddon, Code Enforcement Officer. Shane came and filed for a permit while I was on vacation. He filed it with Bill, so Bill has a lot of knowledge of this as well. It's of our opinion that a flagpole of this size, a structure of this size, does not fit the definition of accessory to residential use. It's more of a commercial size flagpole. So that in mind, we advised Shane to fill out an application for the planning board for site plan review. So I ended up with a formal denial letter, just stating that. So I put in there the ordinances that I used to make my decision. And when Shane came in for the permit, he did bring a proposal, I should say not a receipt, but an example of a 199-foot flagpole with a price and everything all on it. So it was evident that was the intention, was that. So
Does, if I step out of line here. Feel free to.
do you mind if I ask Bill to speak as well?
No, go ahead, please.
Yeah, Bill Schmidt, Poland Range Road. I flown a flag on my property for the past 27 years. I replaced it just 3 days ago. This one's getting a little beat up.
Do you need someone to dispose of that?
Well, yes, I'll take it up to the MVets in Durham. They do it too. Thank you. My flagpole is about 20 feet tall. When I installed the flagpole, I put a 30-inch piece of PVC pipe in the ground and my flagpole slipped right into it. However, much like a truck is a vehicle, a flagpole can also be a structure. A flagpole of this size, of the size proposed, requires a special foundation. For safety, it requires the special setback from property lines depending on the height. It requires special grounding system for lightning designed by a professional engineer. To show respect and comply with the US flag code, it must be properly illuminated. That would require an electrical permit. A flag of 199 feet would require a large mount and intense light to illuminate the flag at that distance. That lighting intensity would likely be an illumination nuisance. The proposed flagpole is both a flagpole and a structure. As a structure, it must go through site plan review per section 801 of the ordinance. Thank you. I don't believe it would.
Anything else like to speak to the topic of
Do have one other thing I forgot. I did look up some examples for residential and commercial flagpoles, and I looked at 3 different companies, including the one that Shane presented to us, and I just have this here to present to you.
Shane, you have anything you'd like to say about these comments?
Basically, as far as like the residential or commercial, I classify it the same as a garage. Like even if you had an oversized garage on your property and you're using it for personal use, it's still considered personal in town of Pownell.
If you were putting up a 10-story that's for use for residential.
So Tim actually used that as a example to me the other day. If I wanted to build a barn that was 100 feet tall, I'd be able to go in and get a building permit for a barn if it only held livestock under the town ordinance. So I don't think it's more of a height thing. I think it's more of a preference.
I'm understanding where the CEOs can. It seems to be that the flag what you want isn't what we would sort of ordinarily expect. A household flag, just like a 10-story garage, wouldn't be what we would expect for a residential garage. A barn should be very tall, very big, but we expect a barn on top of a lot of hay or whatever. But we wouldn't expect that there are uses that by size it seems no longer become what we would think of as accessory use to ordinary residential lot. That seems to me.
So you could, I guess, relate that to mailboxes too. If somebody wanted to put a mailbox that's 3 times the size of a regular mailbox, it wouldn't be considered a residential mailbox anymore. So.
I mean, we would have to see the facts of the case, but there could be some a place where even though someone's calling it mailbox, not really. Every individual case has to decide that. I can certainly imagine say it's not really mailbox.
But also it says in the land use ordinance that there's no height restrictions on flagpoles.
But that's related to the scale against a structure. That it doesn't apply there. Shane, I gotta tell you, a 200-foot flagpole, that's a substantial structure. I have a whole lot of questions about, how it's being set up, or what sort of, guy wires, and all the other, things that apply, lighting, FAA, requirements. I know 200-foot flagpole is a maximum, but still the FAA requires that it not be in a flight path of any type. Determination wouldn't have to be made, sure that it's not in flight. There's a whole lot of questions, something 199 feet tall.
Right. Their intention wasn't to go 199 feet. The intention is to go with the tree line surrounding the house.
We've got to go on what's in the application, which says up to 199 feet. So
Yeah.
have to go on the highest possible height that you propose.
And you said that there's something in the zoning where there's no height.
Right.
Where was that?
It's under the descriptions. It's like the RA.
It lists a number of,
Yeah, no. It says like, buildings not intended for livestock or intended for human occupation.
If you may, Brandon Mazer, I'm an attorney at Perkins Thompson, representing the board. When you get into the RA dimensional standards, which is section 504B for the RA, and then you go into 4E height restriction. No building shall exceed 2.5 stories or 35 feet in height, whichever is lower, except that these height requirements shall not apply to farm buildings not used for human habitation, windmills, flagpoles, wind power generators, or communication towers. But before you get there, there's
It also says that accessory structures, I'm pretty sure flagpole is an accessory structure. Once you get to the site plan review part of the ordinance.
I don't disagree with you so far as what the ordinances say, Shane, but 199-foot flagpole is not something typical now. So while there might not be specific ordinances that say you can't have it above 100 feet, it's incumbent upon us to ensure that, well, things are, the town of Powell is protected. And again, as I said earlier, I have a lot of questions about how a 199-foot flag would be set up.
So when I was talking to the company, basically the rule of thumb is you bury 5% of it underground. So for 10 feet, you're gonna put half a foot, and so on and so on. So for a 100-foot structure, you'd have to put 5 feet.
5 feet.
Yeah. So. But I don't really think that this is that was the intention with the comprehensive plan and the land use ordinance. I think it should have been written that way instead of leave it up to interpretation on. Because don't you think that if there was a height limit on flagpoles that they would have said that there was a height limit on flagpoles like they did on the houses?
The ordinances don't cover everything. I mean, if somebody came into town and said, we want to build an amusement park, well, there's nothing in the ordinances. Yes. But still, the town would have jurisdiction to require that extensive site review is performed before a permit is given to build. Same sort of thing could be said for 199-foot flat.
Chair, the issue before the board tonight is pretty narrow, it's really one jurisdiction.
So the height may or may not be allowed, that really, the question is, does this need to go to site plan review, in which case then the height dimensional. So it's the height at this point, really beyond what scope, what you're looking at, your question should be, what did the CEO have jurisdiction to issue the building permit under the ordinance?
Is the height relevant to that, to the question? Because I don't think it's anybody wants.
No, I think you skipped a few steps in terms of looking at whether or not this type of flag is exempt from site. Which, when you look at, and I think you look at the height.
Isn't the question whether or not this is an accessory use or not, and that would determine whether it's to a site plan review?
Correct.
And so I mean, I would think a 20-foot flagpole is an accessory use, and I think 199 foot is different.
In which case,
May or may not be accessory use that we.
in which case you're getting to the exemption piece because the ordinance allows for so is it to be exempt from site plan review, the construction of one lot or of one single or two-family residential structure accessory as permitted by zoning regulations. Normal agriculture and forestry use, standard development, construction of parking area. Requirements of home occupations. So that's section 801 E of the ordinance. So if this board determines that it is an accessory, that, and there is, I think, a reasonableness in interpreting what a flagpole means. And should be. And otherwise, if it's not part of that exemption, under 801B, it would. And you're not issuing, just be clear, you're not issuing. Even if you were, you would just, if you did find it to be an accessory use, you would just direct the CEO to process the. You would read the CEO. Direct.
It won't be exempt accessory use. Anything about accessory.
So,
There,
so, you have to get, under 202A, the ordinance provides that no building or other structure shall be erected, added to, or started without permit issued by code enforcement officer. In the case of a subdivision or site plan, the planning board must review all out. Further, no development shall take place within Powell, nor shall any land be cleared or altered for any water course be diverted or channel, floodplain bed or built from any parking area, accessory or otherwise constructed, nor shall any building permits, certificate of occupancy or other required permit be issued for any such structure, land or parking area except in accordance with 801A. So you have to figure out if this is a development. Looking at the definitions, going back to the definition of development, definition of structure, and then whether or not this type of flag will meet those standards.
801A doesn't say anything about structure. No development.
No permit, right, so first start with development. Definition of development is any change caused by individuals or entities to improve or unimproved real estate, including but not limited to construction of buildings or other structures.
Okay.
So you have to follow that. You have to follow through.
That's fine.
Yeah.
Anything else you'd like to?
I know that from my understanding, when a town makes the decision on anything, basically. The town also has to follow through in the future if it's considered a like item. And I think this is a case that the town should fix their land use ordinance. It's not a case of does it apply, does it not, is it commercial, is it residential?
We don't.
Right, but it just, yeah, but
But,
with
with
the,
the first selectman here, I'm sure. And I noted, before this meeting that Freeport does have an ordinance that on the side flag.
yeah, almost basically every town around does. More towns have it than don't have it. And in legal terms, from my understanding, a flagpole is considered an accessory to residential house. Because there's no commercial business or commercial zoning on our property on Allen Road, I don't believe you could classify it as commercial.
Well, no, that might in fact be the case.
Okay. Just because you're not zoned for these. But just because you don't have.
Yeah, but that would,
I'm not saying that's this case.
Right.
I'm saying, check.
yeah, just like, I think one of the neighbors runs a construction business out of the garage instead of having it selling for it and everything.
Do you have a view on whether this flagpole is an accessory use?
I would consider an accessory structure to a house. And accessory use. Because same thing getting back to mailboxes, like a mailbox is technically considered a structure. And it's also a use to a house. Same as a fence, same as a flagpole, same as basically anything like a shed, a garage,
What would you? I wouldn't classify mailbox as a structure.
a mailbox is,
Um,
yeah, but a mailbox is considered a structure. So technically under Pownell's land use ordinance, you're supposed to get a permit for a mailbox.
Permit for a mailbox.
Yeah, if you want to,
Mailboxes are addressed.
yeah, but, the way that the land use ordinance is written, everybody that owns a house in Pownell is supposed to get a permit to put a mailbox in.
well,
Right, no, but it's just,
I just want to clarify what I think I said, if the discrepancy, all right, state that.
The code enforcement officer also cited, 504 rural district. One purpose, to conserve the integrity and natural qualities of rural open space for the betterment of the community and future needs. Chairman, I gotta ask you, can't you see what some people would look out the window and see a flagpole 200 feet high? I think, wow. I think that's not really appropriate out here in the woods.
so, are you familiar with the property at all?
No, I'm not.
Okay, so when you're on Allen Road, our whole property is one, well, there's a bunch of trees, but, no, we would be the only ones to be able to see it, and then anybody driving by on it wouldn't affect any other neighbors. So it's not, I wouldn't consider it unsightly. Because it's an accessory use, so if
Anything else you'd like that?
Just getting back to, I think this is a good scenario where the select board should really consider revising and working on their land use ordinance. Do you guys have any more questions about the accessory use, or is it?
We may have
something problems with photos.
It doesn't qualify in the land use ordinance. And,
that's why they can't. Prove it.
they can, but it's considered an accessory use, so it's exempt from the site plan review.
Disagree with. What's that?
It'd be easier and simpler to do an ADP appeal. So, site plan review, I just went through it on another project, and planning board basically just pulled anything and everything out of it to have done, when most of it didn't apply to the project. So I feel like this 5-foot square that I'm gonna dig a hole and put a flagpole in doesn't warrant site plan review.
Hey, I'm an engineer, 5 foot square, but 200 feet up. And as I said, I have lots of questions. How you ensure the integrity and safety of something.
So everything's bedrock.
So these are things that you should put in writing and substantiate. Because if I were going by your place when there was a hurricane and saw a flagpole, I'd want to make sure that someone had done their homework before that flagpole was erected. Ensure that it would never come to something.
There's also nothing within 500 feet except for 3 other trees in the middle of the field. So there's no structures, there's no power lines even, because we got underground power going down the driveway.
There's a road.
Allen Road, but that's roughly 400 feet. Like, it's set almost dead center of the property. If you guys want to do like a site walk on it, or if you want, I can pull up a picture on the maps. But that would also go through Tim for a building permit. I guess basically what we're here to decide is a flagpole considered an accessory use?
Is this proposed?
I'm going to open it to anyone else who might have any comments. No, nothing to be said. Okay. Rebuttal for all parties. If no one else has anything to say, then I'm going to close the hearing. The board will discuss the merits. Could you read out that definition for development? Again, please?
So, I think there are 2 important definitions in operation. The first, development. Development means any change caused by individuals or entities to improve or unimproved real estate, including but not limited to construction of buildings or other structures. It goes on, and I can even pull it. That's the most relevant. The definition of structure is defined in relevant part as anything built to support, shelter, or enclosure of persons, animals, goods, or property of any kind, together with anything constructed or erected in a fixed location on or in the ground.
Any comments?
Remind me why we did determine whether it's development or not. I understand the structure.
So the development piece comes in, because under no development shall take place in Harlem, or shall any land cleared or altered, water course be diverted, or veg or built, or any park areas, pedestrian request, nor shall any building permits, occupancy or other required permits issued for any such structure, land, or park area except in accordance with the planning. So, unless it's exempt, so
Got it,
then
got
the
it.
exemption
We
proceeds.
start with this.
Yeah,
Okay.
I have to agree with you, Alice. It seems like development.
You have to change in, this has to change. What he said,
Yeah, it strikes me that. Element. Structure. So then we have to get. Only. Pose is that. There's a point. Reason. That's.
David, living comments? Well, that did pretty well. I mean, those are my same concerns. I mean, a site plan review, you have to go through engineering, you have to make sure it's grounded. It is gonna be lighting up, I mean, aesthetics. Piece of aesthetics that could really upset, butters. Sort of thinking in terms of, if I was a neighbor and something like that went up and then they started lighting it up, you know, the flag that, I might even say something that I was upset about. It affects, you know, my, the way I feel about in that area. I would, a lot more ordinance theory. I know we're not site plan review, I would. check. Definitely, we should. Agree. Bill? I think that a 199-foot flagpole does not meet conditions of development. Basis. That's what brings us all back to the code enforcement. Denial. Applicability. And impact on board. So. Therefore, I would that be changed. I'm sorry,
So is there a particular height that is considered rural, or is it just any height over 20 feet? It says up to,
but we've got to act upon.
yeah, so that's why. So if I came back tomorrow and asked for a permit for a 100-foot flagpole and came back here in 2 months,
We have to address it, we already would.
Yeah. Yeah. okay. But, also again, to your guys' understanding, you could also relate it to garages or mailboxes or, and it says that.
John, yes. I'm too nice guy. Deliberation and finding of facts.
So, this is
Yeah.
where it gets, and I failed to introduce my associate Teddy back here. We've been, we had drafted sort of some of the baseline, that you may want to vote. We can run through those review of, because we have two options, A, and with B, okay, going. And then you can go to those, or we can try to amend on why we went through all the definitions in our draft finding. Basically. I don't know how you past practices are done. Preference?
I think I would prefer the vote at this point, and if you have information to submit later on.
So we have to, if you vote tonight, which is fine, we have to issue a written signified plan. We've already pretty much drafted that. Not that, but it should be, this board should be comfortable with that. There you'll be signing that gets back. So I think you can find that and vote. I would recommend a roll call. Clean it up and.
All right, how do folks feel, Alice? Any other comments, David?
No, but I just want to reiterate, this, but we're not like voting on whether we like it or concerned
No,
about the
no,
structural, it's just
no.
about whether we're defining it. and all
Absolutely, yes. I move that, the appeal be denied, does not meet. All those in favor?
Second.
Oh, thank you. Thank you, Alice. All those in favor? All those opposed? Shane, I'm sorry, with,
No, that's fine.
yes. Yeah.
What do you know? You want to do it orally, or do you want to do it? Let's do it orally, Becky's not here. That should be back, sure, that should be back by seven. Shall I read the findings that I drafted? Oh, yeah. But I would like to read across one of those. Findings of fact, one, on October 22nd, 2025, appellant that was a kind of follow. Then facilitator deputy code enforcement officer Bill Schmidt discuss appellant's proposal to build a 199-foot tall flagpole at 247 Allen Road, home map 009, lot 006-10 property. The property is in the county rural B zoning district. At the October 22nd meeting, Mr. Schmidt proposed construction for the application for administrative review notes that seeks to be from the decision. Both can and on October 23rd, 2025, the appellant submitted a building permit application to install a flagpole up to 199 feet on the property. A letter dated October 27th, 2025, the county code enforcement officer concluded that the application for a flagpole of 199 feet does not qualify for the structure typically found in a rural district, therefore must be planning board under section 8 the application. Appellant filed the appeal on or around October 23rd, 2025. Included in the appeal package is a list of property owners of the property, a letter from the appellant to the DA dated November 4th, 2025, and copies of the emails to the appellant and Schmidt dated October 22nd. On December 3rd, 2025, the Board of Appeals held a public hearing on the appeal. Present at the December 3rd public hearing were Chairman Paul, BOA members David Steckler, Philip Wentworth, and Alice Alfieri, the appellant, CEO Tim Giddage, and members of the public. Attorney Brandon Mays, who represented BOA as well. In addition to written submissions, and CEO spoke at the hearing to explain it. Appellant had the opportunity to respond to the comment. Conclusion of law. One, jurisdiction. Yeah, let's pause there. Any edits, changes, thoughts on the findings? Conclusions of law. One, jurisdiction. Under the town's land use ordinance, appeal shall lie from the decision of the building inspector or to the Board of Appeals. Land use ordinance sections 207A. BOA has the power and duty to hear and cite administrative review, where it is alleged there is an error in any order requiring decision made by the building inspector. Mr. Brady is a resident of the town of Connell, and the property is the LUO does not define building inspector, but the BOA interprets authority to extend decisions of the LUO section 208B, requiring under the heading administrative appeal procedure, person decreed by a decision of the building inspector or code enforcement to appeal within 30 days of the date of the decision. Granting authority to report the LUO to the building inspector, code enforcement officer. Appellant alleges BOA made an error in terms that application must be reviewed by the planning board. Therefore, BOA has the power and duty to hear and decide this appeal. To stand. The appeal to appeal a decision of the code enforcement officer, a party must demonstrate administrative standing, which means that it created at the proceedings appeal from property or injury or harm. The near guard conflict. Participated in the proceeding by submitting a building permit application and has suffered an injury because the application was in or he must be an application for. Therefore, he is standing to appeal this. Three, timeliness. LUO section 208B required that three parties file administrative appeals within 30 days. The decision and appeal timeline is somewhat unclear record of the appeals time. The appeal site is October 22nd, 2025 at the date of the decision. Written decision is dated October 22nd. The appeal form is dated October 23rd, 2025. The appeal letter is dated February. All dates are within 30 days of each other. Four, whether appellant's building permit application or site plan. The BOA hears administrative appeals anew without first decisions. The LUO section 208H I, requiring the building inspector designated as and allowing him or her to present evidence being appropriate for an understanding of, providing that the Board of Appellants case shall be heard first. Unless otherwise established by charter or ordinance, or shall no any matter to the board may receive any oral or document evidence which shall provide as a matter of basically irrelevant, immaterial, repetitious evidence. Every party has the right to present the party's case, whether granted by oral or document evidence, if not evidence without any part both to disclosure. The narrow issue with BOA is whether a building permit application flagpole requires site plan review by the planning board, may be issued solely by the CEO. BOA concludes that this flagpole is not accessory use in that term. Therefore, subject to planning board or a building permit may be issued. The LUO provides that quote, no building or other structure shall be erected, added to, or structurally altered issued by the building inspector. In the case of a subdivision or a site plan, the planning board must approve the subdivision or site plan for all applicable land use regulations prior to the issuance of the permit. Further, no development shall take place within Hollow, shall any land be cleared or altered, or shall any water course be diverted or its channel or like vegetable, nor shall any parking areas, accessory or otherwise constructed, developed or enlarged, nor shall any building permits of occupancy or other required permit be issued with respect to any such structure and or parking area except in accordance with approval by the planning board of such development, granted according to the requirements of this board. Thus, the initial question is whether a flagpole development means any change caused by individuals or unimproved real estate, including but not limited to construction, buildings or other structure. Construction of additions, expansion, improvements, buildings or other structures, mining, dredging, filling, grading, paving, excavation, building, operation, materials, the storage, deposition, or extraction of materials, public or private sewage systems. Structure in turn is defined in part anything built for the support, shelter, or improvement of persons, animals, physical property, any kind, together with anything constructed or erected at a fixed location on or in grounds. Term these structures temporarily or permanently. Yes. And satellite. BOA concludes that a 199-foot flagpole constitutes development structure which requires approval by the planning board before a building permit being issued, unless it is exempt from site plan review. Exempted from site plan review are construction of one lot on one lot of one single or one two-family residential structure accessory as by normal agriculture and forestry. Now is construction of a parking area for less than 3 vehicles. Interior improvement or requirements. LUO section 801B. Installation of a 199 flagpole is not a single or two-family residential structure or accessory. While there may be flagpoles that are accessory uses used to a residence, BOA concludes that the scale of this flagpole as presented not constitute an accessory use structure. The BOA concludes that this proposal is not what one would typically do. BOA is concerned about aesthetics and safety. For this proposal. Therefore, the BOA concludes that this flagpole application concept site plan review under section and the permit application must be reviewed by the element will be and local. Board noted that the height restriction of the RV is not applied by LUO section 504C 4D. Well, no building shall exceed 2 and 1/2 stories, 35 feet height, whichever is lower, except these height requirements shall not apply to farm buildings. For the least reason, the BOA concludes that appellant's building permit application first be reviewed because of any issue. By a unanimous vote, BOA concludes that the CEO correctly determined that appellant's building permit application for site review by. That's all. Final decision, therefore, on December 3rd, 2025, Board of Appeals voted 5-0 to deny the administrative appeal of Shane Bridges permits building permit application for the required site plan review by. And as always, you'll notice any party agreed by finance. Vote in accordance with main rules. 38 MRS section. Any request for consideration of this? If that also includes edits. Request. That. Vision.
Accept.
Second.
All those in favor? Aye. I'll stick around.
Yeah, well,
Yeah.
let's see. We can. If we email this, you can print it for us.
Appropriate.
What?
If it's appropriate.
Yeah, wait, well, wait, I don't know if anybody has that, but I think it's the formally adjourned.
I don't think there are any other matters to address, so if that being the case, I move to adjourn. All those in favor? Aye. This meeting is adjourned. Yes.